We are delighted with a capital D to welcome to our Zoom newsmaker line right now our friend for many years, a graduate of Vanderbilt Law School, a Department of Justice expert, an election integrity expert, worked for a long time in Fulton County, Georgia. Hans von Spakovsky, Senior Legal Fellow for the Edwin Meese Institute for the Rule of Law at Advancing American Freedom. Hans, it is a great pleasure to have you on. Thanks so much for joining us today.
Thanks for having me back.
Well, you're doing this Court is Adjourned podcast. It's really pretty good. And now, how often do you do it? And I see you're up to episode 9 with our friend Robert Alt, president of the Buckeye Institute. The session, episode 9, is Getting to the Supreme Court Along Thunder Road. Now, people might think that's a little obscure, but I kind of love it. Tell us about it.
Sure. The Court is Adjourned is a half-hour podcast. I do it once a week. And what I was talking about is Robert Alt's the head of the Buckeye Institute, and they have two really interesting cases going on in which they're challenging the federal law that says that you can't distill your own alcohol at home just for your own consumption. Yeah, you can make wine and beer, but if you'd like to make your own bourbon, again, just for you and your family, there's a federal law that says you can't do it. And they're challenging that, saying that the federal government doesn't have the power under the Constitution to do that. And the Thunder Road reference is to a 1950s movie starring Robert Mitchum about a Korean War vet who comes back and takes over his family's moonshine business. And he's facing threats not only from the feds, but also mobsters who want to take it over. And you know, Thunder Road, it was known as an actual road that moonshiners would smuggle their moonshine down. And of course, anybody who knows NASCAR knows that the first NASCAR drivers, the first cars that were used were the souped up cars folks used for transporting moonshine.
Yeah, that's a great one. And, you know, Robert Alt, what a fantastic speaker and great attorney he is. And of course, He's the guy who climbs all the big mountains. I think he was up on Everest, and he's had some harrowing adventures from which he's survived. So he is somebody who understands a risk and reward. Right.
No, he's a very smart lawyer. I think actually these cases are good cases. One's challenging the overreach of the federal government, but yeah, at the same time that he does this kind of great legal work, he literally just a couple of months ago came down from climbing Mount Everest, something that I don't think you or I would ever even want to attempt.
Oh no, I don't even think about doing it. Right. But, you know, there are people that love that challenge, and he's one, and he's very, very well prepared for it. So,
yes.
Well, besides doing a weekly podcast, now the Edwin Meese Institute for the Rule of Law is at Advancing American Freedom. What are the other agenda items that the Edwin Meese Institute, of which you're the senior legal fellow, what other items are you focused on currently?
Well, look, like so many other people, we're waiting for decisions from really important cases from the Supreme Court, all of which we've written about or actually filed amicus briefs in. For example, the birthright citizenship case is currently pending. I actually filed an amicus brief in that case saying that the Trump administration, the current government's view of that is the correct one, which is that no, you are not a citizen if you're simply born in the United States. And in particular, you are not a citizen if your parents are in this country illegally. So we've written a lot about that. We're also waiting on 2 gun cases, Second Amendment, very important cases. They've been kind of overlooked because of the other cases. One of them is out of Hawaii. And in essence, Hawaii passed a law, if you can believe that, that in essence bans folks with concealed carry permits from, I think it's over 96% of the land throughout the entire Hawaii archipelago, all the islands there. And it's clearly just a law intended to restrict Second Amendment rights in the state of Hawaii. And as you know, we've got other cases too, like the one, a very important one. This is very similar to the Tennessee law. As you know, that was upheld last year. This is the one that says that biological males cannot participate in women's sports at the high school and college level. And that affects a lot of different states who are trying to protect women, and we're waiting for that too.
Yeah, that's a lot of stuff. Speaking of Second Amendments, have you seen this? Here in Tennessee, we have the largest retailer of Glocks in the country,
right.
The Glock store. Lenny McGill, he moved the Glock store to Tennessee 6 years ago from California. California basically now has passed a law that says you can't sell a Glock in California. And that, did you see this? Maryland now has passed a law that said you can't sell a Glock in California. That's in Maryland. That's crazy.
Well, it is. And unfortunately, Virginia is now following both of those states down the same line. Mm-hmm. In the last state elections, Democrats completely took over the state, the legislature, the Attorney General's office, Governor, Lieutenant Governor's office, and they have been passing one restrictive gun bill after another, which is quite ironic when you think about the fact that it was in Virginia mm-hmm. that Patrick Henry gave his speech, "Give me liberty or give me death." And what was that speech about? A resolution saying that Virginians should form an armed militia in order to oppose British colonial troops.
Yeah, back to the core of our country. Now, you mentioned an amicus brief. So that can be a very effective tool. Tell our listeners what an amicus brief is, who can file it in a Supreme Court case, and does it make any difference?
Amicus briefs are basically briefs filed by, they're called friend of the court briefs. So if there's an issue before the Supreme Court, like birthright citizenship, on one side of that case, the party is the U.S. government. On the other side are the groups that actually filed the lawsuits. But people who are not parties in the case can actually file briefs with the Supreme Court saying, we have an interest in this particular issue, and we believe you should decide the case this way. And basically, you present arguments on the law, the Constitution, prior cases to try to persuade the court to rule a particular way. The court on big cases gets a lot of amicus briefs, and some of them are very effective, but it all depends on how well they're written and who writes them.
Who can file an amicus brief before the Supreme Court? Can any attorney or any group file it?
Yeah, basically anyone can file. All you have to do is explain who you are and why you have an interest in the particular issue, and then you can file an amicus brief. You can't be directly related to or involved with the actual parties in the lawsuit.
Well, if they get like 50 amicus briefs, how does the court process that? Do the clerks kind of sort through them, or how does it get to the attention of the justices?
Yeah, the clerks sort through them, and when they have a whole lot of briefs, they kind of pick the ones they think are significant. The problem, and it's a waste of time. The problem is it's a waste of time. If people write 10 briefs all on the very same issue, making the very same arguments, that's not going to be very effective. On the other hand, if there's several different issues in a case and an amicus brief is filed on each different issue, those are all going to get read, but they're not going to read 10 or 20 briefs all making exactly the same argument. That's a waste of time.
So when you are looking at preparing an amicus brief on an important question, you've got to look at what argument am I going to make that no one else is making, right?
Yeah, that is the key to an effective brief, one that's going to get read by the Supreme Court justices. I'll give you a quick example of this, one that I organized actually a number of years ago. It was a campaign finance case, and I got together almost a dozen former commissioners of the Federal Election Commission, where I also served as a commissioner, and we filed a brief. And the Supreme Court actually made note of that in its decision. Why? Well, because we were all formal officials who had enforced the law that was at issue in that case. And so that was actually a very effective amicus brief.
How many amicus briefs have you filed or been a part of, and how long does it take to prepare and write one?
Well, I have not officially filed a lot of them. I have filed a small number, but I've been behind the scenes organizing a lot of other people to file briefs. That's one of the jobs that we actually do at the Mises Institute, where I am now, which is trying to organize the entire conservative community to file amicus briefs in important cases. And one of the reasons for that, and you will know this, look, we are outnumbered and outspent by advocacy organizations on the left. Mm-hmm. And frankly, for a long time, whenever an important case would get to the Supreme Court, they would always get lots of amicus briefs from the left side of the political aisle, but not so many from the conservative, what I actually call the constitutional side of the aisle. And one of the things we've really helped on is trying to increase our advocacy at the Supreme Court.
Yeah, and that's very important. And my sense is, with the current composition of the Supreme Court, the kinds of amicus briefs that you would file with the Edwin Meese Institute for the Rule of Law will probably get more attention these days than it would have gotten, 30 years ago.
Oh, that's for sure, because we now have a very good, usual, solid majority on the court who actually will pay attention to the arguments that we make.
Do you try to craft your amicus briefs so that they will address known concerns or perceived concerns of a particular justice? For instance, Gorsuch might have this problem, and we can address it. Or Amy Coney Barrett might have this problem. Is that how you do it when you put this together?
Well, that's sometimes a consideration, but more often it's really looking at, for example, with the Second Amendment. I mean, we look at the historical understanding of the Second Amendment when it was put into the Constitution, and we try to make the Supreme Court really aware of what that amendment was intended to do. In the birthright citizenship case, where we just filed an amicus brief, our biggest point to the justices was to understand what the original sponsors of the 14th Amendment intended with the citizenship clause, which is in the 14th Amendment, and not what all these modern, frankly, ultra-liberal academics keep claiming that provision means, because what they're saying about it is just wrong and is historically inaccurate.
Yeah, I think a lot of these leftist academics are kind of presenting themselves looking at the 13th, 14th, and 15th Amendment, particularly the 14th after the Civil War and Reconstruction. I've heard some of them call themselves progressive originalists, which is rich, it seems to me. You've seen that, right?
Yeah, that's a contradiction in terms. They're trying to put a modern, basically, manipulation onto constitutional provisions like the citizenship clause. And frankly, they're really trying to con the court when they make those kind of claims.
Yeah, but the court's pretty sharp. I mean, these are
Yes.
these are some very very sharp people. Now the Supreme Court justices, boy, they have a lot of work to do. How do they get through all that work analyzing all this stuff?
Well, each of them has 4 or 5 clerks, and the number of cases that they take, unfortunately, has gotten smaller over the years. These days, they only accept between 80 and 90 cases a year out of the thousands, literally thousands, that are submitted to them. Frankly, it's a lot of work, but they have some very smart, highly knowledgeable, and very experienced law clerks who help them do that.
Hans, you've been an attorney for quite some time, very accomplished. Are you optimistic or pessimistic about the rule of law in the United States of America today?
I'm hopeful, I guess I would say. We have a problem in the federal courts down at the trial level and at some of the courts of appeal. We have all these what I call renegade or rogue judges, almost all of them exclusively appointed by Joe Biden or Barack Obama, who frankly don't care about the Constitution or what the law is. And they keep issuing decisions that are just wrong and are clearly intended to get the ideological policy objective they want. Now, on the other hand, many of those most recent decisions, and this has happened a lot in the past year and a half under the Trump administration, many of them have been overturned at the Court of Appeals level, and they've been overturned at the Supreme Court level. But all of that depends on the makeup of the Supreme Court and maintaining a solid majority who are actually going to adhere to the Constitution and the rule of law. And at the lower court level, we have a huge problem with judges who won't do that.
Is there any particular policy mechanism that could address that, given the fact that there's 600 plus trial court, district court level judges, and maybe close to half of them are Biden or Obama appointees? Is there any structural change that could be implemented that could address that problem?
No, I don't really know of a structural change that would lead to that. Part of the problem has been in the past is that U.S. senators, while they have paid a huge amount of attention to who gets onto the Supreme Court, and to a lesser extent who gets on the courts of appeal, for a long time they paid no attention to who is getting on the federal district courts. Those are the trial level courts, and that's where we're getting some of the worst decisions. They pretty much just rubber stamped whoever the president nominated to be on those federal district courts. That's a real failing, and quite frankly, the same attention needs to be given to those federal district judgeships as to those higher courts. Why? Well, those are the judges that handle the vast majority of the thousands of federal cases scattered throughout the country, many of which, when there's a bad decision, don't get appealed.
Yeah, that's quite true. Let me ask you this. You worked at the Department of Justice for a long time during the Bush administration. And, the Department of Justice, I think historically, many people have claimed that many of the attorneys there don't necessarily have an originalist worldview. I think I'd be fair to say that. And some of them are still around. Now, the President Trump just this week has nominated Todd Blanche, the acting attorney general, to be the attorney general. There will be a bit of a confirmation battle. I personally think that's a good appointment. Do you have any thoughts on that?
Oh, I think it's a good appointment, too. Let me tell you, anyone who thinks that the Justice Department is filled with all these nonpartisan, objective lawyers are just wrong. The career ranks when I was there were filled with left-wing liberal activists. In the Civil Rights Division where I worked, the Inspector General actually issued a report more than a decade ago criticizing the department. Why? Well, because, for example, in the voting section, they only hired lawyers from 5 advocacy organizations, all on the left, the NAACP, the ACLU.
Mm-hmm.
They would not hire other experienced lawyers. And I can tell you, those career lawyers acted as if they were still members of the advocacy organizations where they worked. It's just now they had the government's power to achieve the goals of those organizations. And that was unfortunately also true, for example, in the environmental division. So Todd Blanche, if and when he gets confirmed, is going to continue to have a problem with career lawyers who really act like political appointees of Democrats and do everything they can to try to thwart what a Republican president is doing.
I was a little bit surprised when former assistant U.S. attorney for the Southern District of New York, now a columnist for National Review, Andy McCarthy. I don't know if you saw this, but Andy McCarthy came out with a column, I guess, day before yesterday, where he opposed the nomination of Todd Blanche. I was surprised by that. Did you see that? And did you have any reaction to it?
I haven't read it, but while I often agree with Andy on a lot of issues, there are other issues I don't agree with him on, and this is certainly one of them. You may have seen that he also wrote a very critical column recently, actually upholding the dismissal by a Tennessee federal judge of the criminal indictment of an illegal alien who's been in the news a lot, who was indicted by a federal jury.
Yeah, Kilmar and Brigo Garcia. So-called vindictive
exactly
prosecution.
Right.
It was totally made up.
Right.
Totally made up vindictive prosecution. And I mean, Andy, I got to have him on because let's just say you could not be more wrong in that case than he was, because we've covered that extensively.
Right. I know you did, and you uncovered a lot of the evidence in that case. That dismissal by that judge was, as you say, just simply wrong, and yet Andy was upholding it. I don't think that's a correct assessment of the situation. Like I said, most of the time I agree with him, and I think he's a very good lawyer. But I think in this particular case, he's just wrong on the facts of the law.
Yeah, I agree completely. I mean, we wrote a 4,000-word article explaining how wrong it was, because Todd Blanche, had nothing to do with the charges there. The charges for human smuggling came because we at the Tennessee Star broke the story based upon our sources at the Tennessee Highway Patrol that he'd been stopped in November of 2022 and ordered released by the Biden-era FBI. That didn't come from the Department of Justice. That came from our reporting of a Tennessee state government source.
Yeah, and we should mention not just human trafficking, but also the smuggling of drugs and guns.
Yeah.
And the grand jury had testimony from witnesses who were involved in the conspiracy.
Absolutely. Hey, Hans, it is so great to have you on. Really appreciate it. Always enlightening. And we are delighted that you're continuing with your podcast that comes out once a week. Hans, thanks for joining us today.
Sure. Thanks for having me.
All right. That's Hans von Spakovsky with Advancing American Freedom, the Edwin Meese Institute for the